but I couldn't tell who had written them, when they'd been written, and what they referred to.
Did you find that what you found to be helpful at all?
It was helpful to learn the steps that your investigators had taken to find Ms. Rosales and Mr. Cox to subpoena him.
You mean when we were trying to get her and Cox into court?
Yes. The majority of what was in there was reports by, I assume, your investigators or process servers about their attempts to locate them.
When you say in there, that means within what your search within the El Paso District Attorney's Office turned up?
Yes, there were also some of the pleadings that had been submitted by both sides. There may have been one of the protective orders that was in there. It just wasn't in an organized fashion.
Organized or not, what was the content of value to you? What you were looking for, was it there at all?
Just very minimal. It was important for me to know what pleadings had been heard, what had been filed, and what protective orders were in effect, because I needed to abide by those. But nothing of substance regarding all of the allegations that I was aware of.
Nothing of substance. Did you see anything that would seem remotely like an internal investigation done by Mr. Hicks's office?
No.
And what did you think about that?
Well, I was concerned because I was, like I said, was going to have to address these issues in pretrial hearings or allegations made by the defense. I would have to address them.
Let me go back and just touch on a couple of things from our previous questions. Maybe I want to make sure I ask you the right question. You were able to establish for a fact that one person, Claudia Hernandez, had actually listened to the conversations between Mr. Crusius and his lawyers?
Yes.
You were able to find several other, at least 3 other people, if I'm counting right, that it had accessed the folder in which those calls were stored?
Those were people that were still employed with the district attorney's office,
Okay.
yes.
Now, and none of those people said that they had listened to anything?
Correct.
But when you said still employed, did you find some other people that had accessed the file, but who were, at that time you looked at it, were not employed in the DA's office?
Yes, they were employees from the Rosales administration.
Okay. Do you remember who they were?
I remember one of them is Curtis Cox.
Okay.
I don't remember the other names.
So Curtis Cox, who was pretty high up in the Rosales administration,
Yes.
right?
Yes.
You were able to see that he had accessed that folder?
Yes.
Could you determine whether he had actually listened to the file?
No.
But he had accessed the folder.
Yes.
Can you think of any reason why a person might access the folder and not listen to the file?
I don't have a memory of whether in that folder, the audio folder, whether there were other pieces of evidence besides the phone calls. I just don't have a memory. If there were other pieces of evidence in there that were not the phone calls, there would be a valid reason for someone to access that folder. Or they could just access it to see what's in there and then not go further.
Sure. If there technologically were some way to determine whether somebody had actually listened to the call besides Ms. Hernandez, that would be useful to know, wouldn't it?
It would.
And you know about the DVD, but did you also know that GTL had a website?
I know that they have I guess it's a website or a portal or a program. I don't know the proper terminology.
And did you know that it's possible to listen to the phone calls from the GTL website?
Yes.
And that if that had been done but not reduced to DVD, you would know about it?
Correct.
Okay. Did you know that were you told that people in the office, assistant district attorneys and paralegals, could sign in to some sort of, tell me what that means, sign in?
They could access the GTL system. I don't know if you had to get a username or how you were able to access that or how you were granted access to it, but I was told that attorneys and paralegals had access where they could sign into GTL and access whatever phone calls. You had to do a search for, I guess, a defendant. I don't know if you could search for a phone number also, but you could just go in and listen to them there.
And that would be unfiltered calls, that is calls just like wound up on that DVD.
As far as I know, yes.
That is attorney-client calls,
Correct.
as well as other calls.
Correct.
And all you had to do is sign in?
As far as I know, I did not get access to the GTL system.
We learned last night that there have been some policies put into play, but would it have been a good idea to have some kind of policy in the DA's office to prevent attorney-client calls being listened to?
Yes.
May I have just a moment, John?
Real quick, Mr. Stevens. Ms. Hewitt, under the previous administration, there were allegations that a non-assistant district attorney, Roger Rodriguez, had access to the Walmart file. Does that name ring a bell as to somebody who may have accessed this file that contained the recorded conversations of the accused with his attorney?
I can't testify to that.
Okay.
I simply don't have a memory, but the DA's office has the printout from Mr. Cano of who accessed that. I just don't, I don't want to say.
I apologize, Mr. Stevens, you may continue.
Pass the witness, John.
Mr. Davis.
Thank you, Your Honor. Ms. Hewitt, my name is John Davis. I'm an assistant DA. We may have met for a short period, I'm not sure, but anyway, I want to ask you a few questions. First of all, on your understanding of the work product privilege of a district attorney's office, are you aware of the case of Washington versus State? It says that interviews of witnesses in preparation of a party's case for trial is protected work product?
Generally, yes, but I believe there's a case that also says that if it's regarding Brady or exculpatory or even the Watkins case, that is not considered work product.
Absolutely, that is correct. And I don't have the site right now, but you're absolutely correct. But I'm
It might
talking
be
about
OGG.
not exculpatory or mitigating. Are you aware of that case stating that?
I'm not an appellate lawyer, so I'm not familiar with it by the case citation.
Are you aware of post Michael Morton, Article 3914, that says, quote, in the statute, the work product of counsel for the state in the case and their investigators and their notes or report that's work product in the statute?
I'm aware of it generally, but also the state cannot hide exculpatory Brady or Michael Morton.
And ma'am, I'm not saying that, but as I understand, and maybe I misunderstood your testimony, I think you said that none of anything that you ask a witness, none of anything is work product.
I didn't say that.
Okay, so well, tell me your definition of work product.
Well, we use it kind of generally to cover everything. Work product, when we're talking about my notes and what I would turn over, refers to my impressions, my opinions about a witness, whether I think they're a good witness, bad witness. Work product would apply in the note situation to strategy.
So, but your notes, your impressions and what you take down from a witness, now you're saying that is work product.
I didn't say what was or was not work product in my prior answers.
Okay.
What
Well,
I'm
when
saying now is that in relation to my note taking, I would not put what I considered work product, which is my impressions, my opinions, conversations with other ADAs about it, or my strategy.
Let me ask you this then. Let's just say this. You're talking to a witness in a murder case. The witness says, I saw the defendant shoot this person, and I think I was close enough, no obstacles, anything. I saw it happen, and you write that down. Is that work product or not?
I don't know.
You don't know.
No.
You don't know.
I would turn that over to the defense, though, if
But
that's
you
what
don't-
you're
You don't
asking.
know if it's work product or not.
It's not my determination to make.
Okay, if you turned, if after you wrote those notes down, you had another assistant with you, and you turned to them and said, well, I think this would be a good witness, let's put this witness on second in the case, is that work product or not?
Probably.
Okay.
And that's not something I would put in my notes,
But
that
the
I
first one
but I
you
would
have-
turn that over to the defense.
But the first one, you don't have any idea.
It's not what I said.
Okay,
I would
well,
turn
what
it
if,
over to the defense, is what I would do.
but you don't know if it's work product
It's
or not?
not my determination to make.
Okay, all right. All right, well, let's get to what you did turn over as exculpatory or mitigating evidence. What, at the time you were still working, did you turn over exculpatory and mitigating evidence to this defense team?
Yes.
What did you turn over?
I turned over a memo regarding Enrique Adelano, who
Okay.
came into the courthouse with a weapon.
Okay,
I turned over a memo regarding Kurth, the Florida witness, and I turned over information about the phone calls. There may have been more, but I just don't, those were the three main ones that I remember.
I didn't understand, and you turned over, what was the last one?
The phone calls.
The phone call. Did you also turn over a statement from the FBI that Mr. Litwin, John Litwin made?
Did I turn it over?
Yeah.
Well, that was part of the case file in Portal, I believe.
So you believe it was turned over?
Yes. I don't think I personally turned it over. I think it had already been turned over.
Okay. Anything else that you remember is exculpatory or mitigating that you turned over?
Not off the top of my head.
All right. So if I understand your testimony, 20 or so witnesses that you interviewed for possible witnesses in the trial, that some of them had what you believe to be mitigating evidence, or at least arguably so.
Yes.
All right. And you did not turn that over?
That's what I was going to turn over in my notes.
Okay, but you did not turn it over?
No, because my notes have disappeared.
Okay. Right here, right now, at least as far as what you remember that's exculpatory or mitigating, tell the court and tell these defense lawyers what you remember is exculpatory or mitigating of those 20 witnesses.
That they didn't want the death penalty for the defendant.
Okay. Are you
From
aware
the
of a
family
case?
members.
Are you aware of a case that says no one can give that opinion? Where a witness can't get up there and say, I think you ought to get life, I think you ought to get death. Are you
Yes,
aware
and
of
I've
that?
also had the experience where defense attorneys do that anyway, and the judge allows them to answer.
Well, but you understand the law is that you should not be able to.
Of course.
Okay. But you think that's exculpatory or mitigating?
Yes, could be.
Okay. Anything else of those 20 witnesses?
Without looking at my notes, no, I can't remember anything.
All right. As far as Karen Kurth, is there anything outside of your, I guess I'll call it your memo that you turned over that you think was exculpatory or mitigating?
No, what I turned over was what I believed to be, but I was still going to turn over my notes in case there was something that I didn't think was exculpatory or mitigating, but could be arguably.
But you think you made a complete turnover?
Yes.
As far as John Litwin and the disclosure from the federal case, do you think there's anything outside of that that would be exculpatory or mitigating that didn't get in that release?
I'd have to look at my notes,
But I'm just asking if you remember anything.
not without looking at my notes.
Okay. Now, as far as additional neighbors other than Kurth or Litwin that you talked to, is there anything in their discussions with you that you think was exculpatory or mitigating?
Yes.
All right, right here, right now, would you please disclose that to the defense team and to the court?
Yes, that they thought he had mental issues, that he wasn't right, that he had been bullied, that there's no way he could have committed this offense by himself, that he had been indoctrinated, that his parents had tried to get him help for all of his mental issues, that he had outbursts in class, that he was in special education, that he wasn't right in the head, that his parents probably should have not let him live when he was sickly as a child. Those are some of the things I can remember, but again, without my notes, I can't tell you all of them.
And besides what you released, and besides what you've told us here today, can you think of anything in the case, whether that you read or witnesses that you talked to, neighbors, anything else that you remember that has not been disclosed that you can tell us here today?
I can't remember without looking at my notes.
All right. So we've exhausted as far as what you know about exculpatory or mitigating or what's been disclosed, other than what may or may not be in your notes.
Yes.
Now, the 4 calls, just so it's, well, how many phone calls, when you realized that was happening with Mike Williams, was it 4 phone calls?
That I found, yes.
All right. And you delivered a disc of that back to the defense, is that correct?
The original, yes.
All right. May I approach the witness, Your Honor?
Yes, you may.
Can I show you what's been marked as State's Exhibit 1 and see if that looks like a fair facsimile of the delivery of that, and I guess a photocopy of front of the DVD that went back to the defense?
Yes.
We'll tender State's Exhibit 1 to evidence.
No objection.
For the purpose of this hearing only, State's Exhibit 1 is admitted into
Your Honor,
evidence
are you collecting these, or where are we collecting these?
with my court report.
Thank you. For sure, though, as far as you and Mike Williams, and who else was with you?
Where?
Did any of those
Where?
in the room listening to?
Oh, I'm sorry.
Or attempting to listen to the DVD?
Okay, I'm sorry, ask me again.
Okay, did anybody access that DVD?
No.
So none of y'all listened to the DVD and it went back to the defense?
Correct.
Now, let me show you also. May I approach again, Your Honor?
Yes, sir.
I'll show you a memo and see if you recognize it first, I guess.
Yes.
What is that?
This is a memo that I created to memorialize what had happened regarding the phone
Does
calls.
it appear to be true and correct?
Yes, it doesn't appear to be altered.
And this is a memo of what happened with that DVD incident, I'll call it.
Yes, that wasn't everything, but that's what happened.
Okay. Tender States Exhibit number 2.
No objection, Your Honor.
For the purpose of this hearing, State's Exhibit 2 is admitted into evidence.
As far as you know, well, let me back up on that folder. Do you know, if I was to tell you that there were 911 calls in that folder, would that ring any kind of memory on your part?
No, like I said, I don't remember if there were other audio files that were in the same folder as the phone calls.
All right, well, your testimony is you don't remember what else was in the folder.
Correct.
Now, you spoke with, for sure, Claudia Hernandez, correct?
Yes.
And your recollection is she said that she listened to some attorney-client phone calls, correct?
Yes.
But that she also told you that she did not disclose that to anyone.
I believe that she told me that she had not told anyone else about them.
All right. And your instructions to her right at that time was to, well, don't tell anybody
Right.
about the calls. All right. Let me, may I approach again, Your Honor?
Yes, you may.
Let me show you State's Exhibit 3 and see if you understand this to be your disclosure on Ms. Kirk. I would take it your Brady disclosure, and you can tell me how you characterize it.
Yes. Yes, that's the disclosure and the email to the defense.
Anything outside of this, now that you're looking at it, in addition to this, that would be exculpatory or mitigating that you can remember from Ms. Kirk?
No.
Do you think this is pretty full, in other words, that your notes wouldn't help this, I guess is what I'm asking.
I don't know without looking at my notes.
Okay. But as far as you know, this is a full disclosure?
Judge, she didn't say that. She said she needed to look at her notes.
Overruled. You can answer if you can.
You want to look at it again?
No, I'm familiar with it. I need to look at my notes to determine if there's something I left out of there.
But as far as, well, I guess my question would be, as far as you know, when you made this memo, was that a full and fair disclosure of what she had to say to include exculpatory and mitigating evidence?
I was attempting to give a full and fair disclosure, but that's also why that's why I was going to turn over my notes in case I missed something in there.
Okay. Tender States Exhibit number 3.
Your Honor, I think that we don't have any objection to this, but I think it should be sealed, right, because it contains some things.
It's going to be for the purpose of this hearing only. And so it's not going to be used for anything else but for determinations by this court on the motions that have been filed.
I understand, Your Honor. Would it also be sealed, though, I think, at least until some later date, when we can determine whether it should be made public.
This court will always entertain sealing in accordance with the law.
Well, we do ask, we think this would be an appropriate matter to be sealed, Your Honor, because of the nature of the case.
Yes, sir. The request has been made. The court will review all its exhibits for this case and make that determination and inform both parties at the appropriate time.
We have another exhibit, may I approach again?
Yes, sir. Let's show it to the defense counsel before the witness.
I want to show you what's been marked as State's Exhibit number 4, two-page document. Do you recognize that?
Yes, that's the memo the original memo that I sent to the defense regarding Enrique Edelano.
And does it show the disposition of that case as far as what you know and what you related to the
Well, there was more that was relayed to the defense after that memo.
Okay, what was that?
I think that the defense had sent me maybe an email. I don't think it was a formal pleading. I think they had sent me an email requesting additional information. I think they had a list of questions in there, like, is there video? I can't remember all of the questions. And I responded to that inquiry. And before I resigned, we were in the process of obtaining the video and all the reports and everything that would respond to their request.
And did you release that to the defense?
I believe that I had responded at least in part to it, and there may have been some of the questions I may have responded that I'm still working on it.
Was it mainly video and law enforcement reports?
It was no, they had asked the identity of the ADA who had rejected the case. They had asked for names of maybe who had been involved or had notified me about the situation. They'd asked for video and recordings of the situation. I can't remember what else they asked about that.
All right, but you did make a further release of...
I did. We had obtained at least one of the police reports. I had answered the questions that I could, or with the knowledge that I had regarding the ADA and the reason for rejection. Actually, one of the bailiffs was one of the officers who was attempting to comply with the request for the video, and he was in the process of doing that.
Tender States Exhibit number 4 there.
You know, we have no objection to this. However, under the rule of optional completeness, we do ask the district attorney to look in there wherever they found that and look and see what the follow-up that Ms. Hewitt was talking about, and then try to get that into evidence. I'll look in my files too.
Can you get back to us on that?
Yes, Your Honor.
Thank
We'll
you.
try to...
For the purpose of this hearing only, State's Exhibit 4 is also admitted into evidence.
We'll try to find it.
Yes, sir. Thank you.
Your Honor, may I approach again?
Yes, sir.
I'm going to withdraw this.
Thank you.
Ma'am, how far back do your notes go as far as you recall?
The pretrial notes?
Just your, yeah, the pretrial notes in this case.
Those, I didn't take any notes when I was doing the meet and greets with the family, so the notes would have started when I started doing the pretrials or the interviews with potential experts.
So when did you start taking notes? I mean, would it be the second meeting, or?
Well, when I started doing pretrials was maybe June. That's a guess. I had spoken, if I remember correctly, I had spoken with one or more potential experts before I started doing pretrials, and I would have had notes about that. Those would not have been notes that I would have turned over.
But, so, not experts, but fact witnesses you were going to release?
I'm sorry. Actually, I did not start doing the pretrials until I had a full team. So that would have been after Rebecca Tarango and Mike Williams were brought onto the case, which would have been around August, if I remember correctly. That's when we started doing pretrials.
The, were you going to release, like, all your notebooks to the defense?
Yeah.
Okay.
All my pretrial notes, yes.